Hello, and thank you for joining this training video on crossing the cultural divide, practical ways lawyers and mediators can better work together for the benefit of the public. My name is Janet Whitehead. I'm a lawyer and a full-time mediator arbitrator practicing in Sarnia, Ontario. I'm accredited through the Ontario Association of Family Mediators, otherwise known as the OAFM. I'm also one of the original members of the steering committee for the Family Law Limited Scope Services Project and was directly involved in the development of the Best Practices Guide and training curriculum for that project. By way of background, the focus of that project was to support and encourage family lawyers to engage in providing limited scope services, also known as unbundled legal services, to Ontarians as a way to increase access to justice for separating spouses who might not be able to afford full representation by a lawyer. The rationale was that some access to legal representation and assistance to navigate the family justice system was better than no access. The already overburdened court system was suffering from the strain from the increased number of litigants who were attending court proceedings without the assistance of a lawyer. We knew that engaging in an adversarial process and enduring lengthy or unnecessary delays in reaching a resolution only served to increase the level of stress and exacerbate the pain, frustration, and trauma experienced by separating families. The project recognized that the public desperately needed access to timely, affordable, and effective options for resolving their family law matters and tried to address this need from the perspective of increasing access to legal representation, albeit on a limited basis. However, some of us who practice family law recognize that there was more to be done to build on the project's work to date. The court system may be necessary for dealing with high conflict family disputes, but many people have been turning to other consensual dispute resolution processes in the hopes of finding a better way to resolve issues. CDR options in family law provide value by allowing parties to design their own solutions with as much professional assistance as they may want and need in a way that reduces conflict, reduces the resulting harm to children, and preserves relationship. Increasingly, the focus has been on mediation as an affordable alternative to the court system, whether within the court-connected on and off-site mediation services supported by the government or by private mediators. Mediators may have a background in law, but often may come from different disciplines such as social work or other mental health fields, or with a background in finance. Separating partners still need the responsible assistance of lawyers to ensure that the parties clearly understand all of the possible consequences of their choices, achieve a sustainable and durable agreement which will be respected by the judicial system, and minimize the risk of future conflict. And separating individuals need to be able to find lawyers who are willing to provide this assistance in the context of a negotiation process where the lawyers are not directly involved. Again, a type of limited scope legal assistance. Next slide, please. Which brings me to the purpose of this presentation. As a family law practitioner who has transitioned to mediation, I and some of my co-presenters today have the unique opportunity of understanding the very different perspectives, goals, attitudes, responsibilities, and potential liabilities which accompany the very different roles of mediator and advice lawyer. We have also experienced firsthand the reality that far too often mediators and advice lawyers operate in their own silos with little understanding of what the other does, the value it provides to the overall outcome, or the challenges each faces in providing service to their clients. Two solitudes, if you will. Separating spouses need help with communicating with their former partner, help with understanding legal rights and obligations, help with imagining options to solve a dispute or a problem, help to make informed choices and decisions, help with documenting the specifics of a solution in a way which is understandable, unambiguous, and forcible and will minimize future conflict. There is a role for both advice lawyers and mediators in providing this help. In discussions with various colleagues, it became clear that both advice lawyers and mediators could benefit from some direct training on these issues in order to cross the cultural divide, with a focus on how each can better support the role of the other for the overall benefit of families in Ontario. Next slide, please. The content of this presentation is the result of much hard work on the part of an ad hoc committee of dedicated volunteers. I'm very pleased that most of these committee members are here with me today and will be taking turns speaking to different topics on our agenda. By way of introduction, they are Marianne Popescu, Executive Director of the OAFM. She is a mental health professional who's both an accredited family mediator and an accredited intergenerational mediator. She is located in Toronto. Joanne Beasley is a practicing family law lawyer and accredited family mediator through the OAFM. Her practice is situated in London. Yvonne Bernstein is a litigation director and lawyer with the Lawyers Professional Indemnity Company, otherwise known as LawPro. She is located in Toronto. And Aubrey Sherman is a practicing family law lawyer and soon to be accredited family mediator. His practice is in Kitchener. I want to thank all of them for the incredible amount of time and energy they have committed to this project. I just want to give you a brief explanation of the topics to be covered and by whom. Aubrey and Marianne will address ways to build better working relationships between mediators and lawyers in getting along in the sandbox. Joanne and Aubrey will discuss the value of legal advice in the mediation process. Yvonne will cover professional responsibility and risk management for lawyers. I will cover sustainable mediation reports. Marianne will cover drafting for mediators. And I will finish off the program with talking about what to do if issues arise after the mediation and before the necessary documents are signed. Next slide, please. So now I will turn it over to Aubrey and Marianne for getting along in the sandbox.
Thank you, Janet. Families in transition are increasingly turning to mediation as their preferred consensual dispute resolution process. Families who choose mediation do so for the advantage of being able to work towards their own creative solutions. The shared goal of the family, the mediator, and the lawyer is to achieve a sustainable and durable agreement that the family is able to follow, that minimizes the risk of future conflict, and an agreement that is respected by the judicial system. These families require assistance of mediators and lawyers who are able to work together in order to ensure that the clients understand all of the possible consequences of their decisions. For all these reasons, when mediators and lawyers are able to work together in the mediation and independent legal advice process, they set a good example of teamwork that the family may be able to follow. I would now like to welcome Marianne into our conversation about the importance of the mediator and working together with the lawyer.
Thank you, Aubrey. So I think that Janet said in her opening about working together to sort of build community connections across all family law professionals. So really one of the key components of this presentation is to encourage us as professionals to develop relationships of trust, to increase our communication with each other, and really try to help each other out in helping the families really to achieve agreements that are fair and durable. Families need you. They need your help to give them this independent legal advice piece. It's a key component. And the OAFM standards include a very, very positive obligation for mediators to encourage independent legal advice throughout the mediation process. And really what we'd like to see is a family-focused approach. What works in the office may not work at home, and we really need to think of how we can get along better and communicate very effectively so that families can live their lives outside of our offices to their fullest potential.
An effective team is one that works together to identify the needs of the family, and those needs can often change and evolve over time. And then the team needs to be responsive and accommodating to those changing needs. Teams that work well together will often emphasize and rely upon the unique skills and experience that the professionals bring to the process. The professionals will also know their limits and when it's appropriate to seek the assistance from other professionals. These effective teams regularly debrief. They assess and reevaluate process, not only with the family, but amongst themselves. And they do so to encourage an open and ongoing dialogue.
So I think that one of the key components that we're sort of going to be talking about today is this ongoing communication and really effective communication between professionals. And that also is a responsibility of the mediator to encourage the client to keep the lawyer and any other professionals updated to the stages that they're at in the mediation process, and really to know when to reach out. In addition to the regular check-ins, when a key legal issue needs to be weighed in on prior to the mediation continuing. So debriefing regularly, understanding what additional referrals need to be made to help the clients identify possible options for them are really, really important. And also mediators are responsible to know what's happening in the community case law, what's going on with, say, notional or contingent liability on the sale of a home in your area. And this is especially important when we're learning that many of our mediators across Ontario are working in broader communities. So we need to know and check in with the family law professionals, and really the family law professionals, if they can share information like, hey, this is what's happening in your area that you're mediating this file. And then there's understanding what the next steps are. So sort of how does this all sort of come together? Say you have a family and they each have received independent legal advice. How do they sort of incorporate the individual legal recommendations, which could be quite opposite? They could be competing. And so how does the family eventually get to agreements being signed? And I think that the idea of creating these relationships and even mentorships to make it enjoyable for lawyers and family law mediators to work together can really help with the clients getting to the end of the process. So Aubrey, back to you.
So clients often ask us as mediators and as lawyers, what is the value of legal advice in the mediation process? Next slide, please. Clients need to understand and be encouraged to see the value of legal advice in the mediation process. Some clients don't necessarily see the value of legal advice. They see it as an unnecessary expense, and they want to mediate to come up with an agreement without the need for the involvement of lawyers. Other clients may state that they have a good understanding of the legal terms and they want a streamlined process that works within their fixed budget. It is the job of the mediator and the lawyer to explain to the clients that there is considerable value in the legal advice that a lawyer can provide as part of the separation process. Clients will then ask, what is ILA and why do I need it? Essentially, ILA in a family law context is providing a client with information, options, and a cost-benefit analysis combined with the recommendations and opinions on the legal issues arising for a party and a family in transition as a result of the separation. Next slide. The purpose of ILA is to ensure that a party signing an agreement understands its contents, including the legal consequences arising from the agreement. Typically, ILA will include a review of the legal and financial responsibilities that the parties are committing to as part of the terms of the agreement. ILA will also include a review of the legal and financial rights that a party may be conceding. Mediators often deal with issues that matter most to the family, including the parenting schedule, decision-making responsibility for the children, financial obligations, the matrimonial home, and issues related to property. Often, the parties lack an understanding of the legal terms that are set out in the agreement, and it is the role of the lawyer retained to provide ILA to ensure that the parties understand the releases and legal jargon that form part of the agreement. Next slide. In discussing what ILA is, it is equally important to distinguish what ILA is not. Providing legal advice in ILA is an important and vital part of the mediation process that must occur with proper attention and skill. ILA often takes considerable time to provide to a client, and it requires careful review and consideration. As an essential service that requires more than routinely witnessing a signature, and it's not just a meet and greet with a lawyer or the rubber stamping of an agreement. ILA requires due diligence and meeting with a client to ascertain that the client understands all of the terms of the agreement in a manner and way that they can explain to a lawyer using plain language and in simple terms. I would now like to welcome Joanne to join our conversation with some practical examples of the importance of legal advice as part of the mediation process.
Thanks, Aubrey. We have all likely had the situation that our car is not working. My goal in that situation is to get the car going so I can proceed to shop, get to work, etc. Certainly, I'm going to think about gas and the battery first. For a mechanic, they need information to provide options and make recommendations to me. Some information may come from me, some from their knowledge and expertise, and perhaps some from fancy computer diagnostics. I don't know, but I do know I need the analysis and options before I give the go-ahead to fix it. Without the information, my instructions are not going to make sense. I need information, options, and analysis. With a cost-benefit analysis in mind, I need advice. Perhaps the repair is $5,000, but it's an old car that may be worth far less. The mechanic may also be telling me most likely scenarios and noting no guarantees until certain parts are removed and checked. Next slide. I need information, options, and recommendations. Ultimately, it is my car and I have a choice to make. If a parent attends mediation without legal advice, they simply do not know what is possible or likely. They do not know their options, and there has been no analysis of the options to their particular situation. How can they make a decision that is sustainable without being informed? Independent legal advice is the trees and the forest for parties negotiating and entering into terms of settlement. It is the information asked of a party and provided by a party. It is the options outlined, analyzed, considered by lawyers, mediators, and the parties. It is also partly a cost-benefit analysis. Next slide. A parent is trying to figure out the best solutions for their children. They're learning a new language. Legal words are often a challenge. They are dealing with new circumstances arising from their separation, and often they are facing heightened emotions. It can be a very challenging time. There are short-term goals and long-term goals can be determined. Short-term impact and long-term impact of decisions matter. They likely have some opinions based on what other families are doing after divorce, and perhaps some legal advice from friends and family has been provided. But what do they need? They need to know about the best interest factors. They need to know what options are available for shared parenting, for non-shared parenting, what schedules, decision-making options are available, what holiday schedules could be used. The options available need to be tested as to the needs of their specific family situation. You sometimes hear that the parents know what they want and merely need someone to write up the terms for them. Often they know they want to share parenting time, or more likely, they may still be using the old terms of joint custody or custody and access and not understand what the new terms mean or that they need to be used. They want the label of a shared or joint parenting plan, but have not actually discussed or agreed to or truly considered the details of the time sharing arrangement, which could be beneficial for their family. They do not see the need to consider what happens in the summer, what happens at Christmas, what happens when there's a special occasion, what happens when they disagree. They need advice and options for a sustainable parenting solution. That is independent legal advice. Aubrey?
Thanks, Joanne. Outside of my professional role as a family lawyer and a mediator, I enjoy baking. In baking, we use recipes that are tried and true. We don't start from scratch when we're baking a cake, and the same applies to our role in ILA. Next slide. Experienced lawyers who provide ILA often consult with a checklist to ensure that they provide a comprehensive service to the client. There are a variety of checklists available to consult, including those available on the Law Pro website under Lawyer Resources. A lawyer providing ILA must remember to explain legal terms of the agreement in a way that the client can understand. To do so, it is often helpful to have the client explain their goals, values, and interests at the beginning of a consultation. In this way, a lawyer can use that information as a framework for providing the ILA to the client and to ensure that the agreement adequately meets the client's needs. Very often, the client will indicate that maintaining good relationships matter most to them, or that they want a clean break without future uncertainty. Next slide. It is helpful that a newly separated client be aware of the options available to them and creative options that other family law clients have previously chosen. It is equally important to ensure that the client can understand and explain to the lawyer the terms of the parenting plan or schedule so that it can be followed in everyday life and not just as a schedule or an appendix to an agreement. Legislation and the law needs to be explained to the client in a way that the client can understand. The client needs to be encouraged to review and select options that will work best for them and for their family. Next slide. A family may have children whereby the child support needs to be addressed, but unless the guideline calculations are completed, they may not have an understanding of the factors that are reviewed in discussions relating to child support. Understanding the factors that are part of the child support calculations are a critical component to the mediation and to the independent legal advice process so that the client understands the terms of their position and future agreement. Often, a divorce mate calculation can be a helpful tool and visual aid in discussing this area with a client.
Legal advice requires obtaining and providing information and the analysis that comes with it. One lawyer, one client is a basic starting point. Each person's perspective is different. Their information is different. Their goals may be different. A lawyer cannot act for two sides of a dispute. This is true even if the parties articulate that they are agreed, know what they want, and basically want a scribe to write out the terms of the agreement. Unfortunately, sometimes the premise of one client, one lawyer is broken. A few months ago, a separation agreement crossed my desk where both spouses had signed in front of the same lawyer for a fee, and the lawyer had stamped, "No legal advice sought or given." This means that the lawyer had purchased a rubber stamp for the purpose of witnessing people sign agreements. And the stamp was to convey that no legal advice, information, or options had been exchanged, and that he wanted to confirm no legal advice sought or given. Perhaps the lawyer felt that the stamp saying no legal advice sought or given would be acceptable to Law Society review. I don't speak for the Law Society, but I would say no chance. From the perspective of the clients, what is their intention when they pay a lawyer to finalize a separation agreement? That it is appropriate, sustainable. In order to accomplish this, independent legal advice is required. Of course, the separation agreement where the one lawyer signed for both clients was not written well. It included such terms as joint custody with the 50-50 schedule to be agreed upon. No details in old language. The agreement provided for no child support, despite a huge income difference between the parties. The financial arrangements for their children were to be agreed upon later. There were significant legal issues left for the future, and yet final releases on property and other matters were included. This is an example to remind us of the value and purpose of legal advice and the premise of one lawyer, one client. It is standard practice for there to be an acknowledgement that a person signing a separation agreement has had legal advice, believes the agreement to be fair and reasonable, that they understand the terms, and that they are voluntarily signing the agreement. I believe these paragraphs should be within the agreement. The separation agreement is signed by the parties, and they are the only ones who can make these confirmations. For some lawyers, it is standard to sign separate pieces of paper titled certificates of independent legal advice that set out the same information with the lawyers confirming the statements. I personally do not sign certificates of independent legal advice. I include the confirmations within the agreement, which is signed by the parties. I have been asked why. Partly, my answer is a situation in my office many years ago. And I will tell you the end of the story first. Nothing bad happened. What did happen is that a client to the firm met with an associate lawyer. The husband's lawyer had sent over a draft agreement with terms that had not been agreed to. The woman client said she wanted to just sign and get it done. The woman's lawyer explained that the terms were not what was in her best interest, had not been agreed to, and that more information was needed. She accepted his advice and left the office. At her next appointment with the lawyer, the client advised that her husband had driven her to the last appointment, that he was out in the parking lot, that he had told her she must go in and sign the agreement that his lawyer had sent over, and that he had a gun. If the woman had insisted on signing the separation agreement, and the lawyer had followed her instructions, and if it was his practice to sign certificates of independent legal advice, he would have been confirming that she understood the terms of the agreement and was signing voluntarily. If later the woman had tried to set aside the separation agreement on the basis of duress, her own lawyer's certificate of independent legal advice would have been used to discredit her position. At least if the terms were within the separation agreement, her own lawyer would not be pitted against her signing of the agreement. Lawyers can do their best to ensure a client understands options and what they are agreeing to, and assess that a client is doing so voluntarily. In my view, we cannot confirm why a client is doing something. Knowledge of the client's understanding, state of mind, and emotional state is their knowledge, not mine. Next slide. Negotiation and mediation virtually always means a give and take. A person needs to be aware of their options, legal rights, entitlements, legal duties, obligations, and the costs and risks. They need legal advice. The decision is then theirs to make, often in mediation. The terms of settlement agreed to in mediation are likely a mixture of what the clients individually wanted, and only the person knows that they are okay with making those choices and entering into the agreement. It is only within their knowledge that they feel they understand the terms, what they are agreeing to, their rights and releases. As a lawyer, I have my professional responsibilities, but the actual knowledge of understanding is that of a client. Next slide. To have meaningful mediation dialogue and to obtain a sustainable mediation report and separation agreement, it is in everyone's interest that the process and the paperwork is understood and considered fair by the parties. Clients receive value to their understanding and their negotiated positions with independent legal advice throughout the process. Ultimately, the independent legal advice process is about ensuring that people understand options and are assisted throughout the process of decision-making with advice, recommendations, cost-benefit analysis. And mediation is a great, effective process for the negotiation, and the parties need legal advice to understand the potential terms and outcomes that can be discussed and agreed to in mediation. It is the foundation of their bargaining power and decision-making capacity. I would now like to welcome Yvonne to our conversation with regard to professional responsibility and risk management.
When it comes to domestic contracts and settlements, Lawyers who provide independent advice face risks which often do not come to light until long after the contract has been finalized. What are the risks faced by lawyers? To place this into its proper context, let's consider some statistics. 42% of all family law claims reported to LawPro arise out of contracts and settlements. Communication failures account for 39% of the claims, errors of law 22%, and inadequate investigation and time management issues are almost tied at 9% and 10% respectively. How should a lawyer manage the risks presented through these errors so that he or she can provide the client with effective representation that will promote the goal of having a binding and durable settlement? The lawyer must adhere to the professional standards mandated by the Law Society through the rules of professional conducts. The standards are the same regardless of the scope of the retainer. It's important to appreciate that limited scope retainers are as challenging as full scope retainers. In fact, they can be even more challenging as a result of the constraints imposed due to time pressures and the client's limited financial resources. The usual processes incidental to a lawyer-client relationship must be followed. That includes having a retainer agreement, keeping notes, screening for family violence and power imbalances, and all of the other usual steps that a lawyer will conduct incidental to a retainer. But the key is this: to give proper advice, the lawyer must have the necessary knowledge, skill, judgment, and must take the time to fully understand the client's situation. And by the situation, I mean the client's full situation, including past, present, and future. This is not something that can be done in an hour. Giving proper advice takes time, and there is a cost. But if it is not done properly, the result will be a settlement that is vulnerable to a subsequent challenge and a likely claim against the lawyer. Many of the errors we see most often, which give rise to claims, arise from a failure to properly understand the client's situation, the client's goals and needs, and identify to the client the issues from a legal perspective that flow out of that situation. Examples include misunderstandings with respect to the finality of a negotiated settlement, failing to properly identify all of the issues and remedies to be addressed in an agreement or settlement, including constructive or resulting trust claims or reckless depletion of net family property, health issues that may impact the amount and duration of support, or the importance of extended medical benefits, and failing to address what will happen with those when those benefits are no longer available. A thorough intake and assessment process is critical to understanding the client's situation and being able to move on to the next phase, which is giving appropriate advice. And that includes a history of the relationship, the roles played by the parties, and any health concerns facing either of the parties, just to name a few issues. Of course, it also includes full and complete financial disclosure. Financial disclosure is a critical component to the integrity of the process. Without it, the integrity of the ultimate bargain is compromised and the path is paved for a challenge to the agreement. Once that due diligence phase has been completed, the lawyer is in a position to provide analysis with respect to the proposed settlement or agreement and advise the client. The client needs to understand the terms of the settlement and how it compares to his or her legal entitlements. Every settlement is based on compromise, but the client needs to understand what they are giving up, and that can only be determined by understanding the legal framework within which we operate. Communication best practices. Good communication is critical to a successful lawyer-client relationship and to the integrity of the process that will hopefully culminate in a comprehensive binding settlement that the parties will respect and live with. The lawyer needs to be alert to situations where there are extraordinary pressures on a client. For example, a pending real estate transaction that is about to close and the need to provide a mortgage lender with proof of a separation agreement in order to obtain funds. That kind of pressure can result in a client making a very bad deal, which they will come to regret and try to extricate themselves from once the immediate pressure is over. And speaking of communication, does the agreement clearly set out what the parties agreed to? Has it been clearly drafted? Are the terms consistent? Has anything been left out? If the agreement refers to schedules, are they all attached? These are some of the most commonly seen problems which cross our desks. The benefit of using a checklist to cross-reference against the agreement cannot be overemphasized. It is important to provide the client with a reporting letter as well as an account when the file is ready to be wrapped up and closed. The reporting letter should outline the issues and the work done on the client's behalf. Many contracts require follow-up steps. For example, a real estate transfer, follow-ups with respect to life insurance, closing joint accounts or lines of credit. The responsibility for those future steps must be clearly outlined. If it is the client's responsibility, the client must be clearly advised, and the steps that need to be taken should be explained along with any timing considerations. In other words, any loose ends have to be properly addressed. Once all of that is done, the file can be closed, the lawyer's work is done, and hopefully the clients will have a binding agreement that they will be able to live with for many, many years to come. Thank you.
I'm going to turn now to talking about sustainable mediation reports. So what do we mean by a mediation report? Well, it's a document that's prepared by, actually, if you go back to the previous slide, please. There we go. It's a document prepared by the mediator who sets out the term of the consensus or the resolution reached in mediation. It may also include some narrative about the discussions between the parties. It's generally not signed by the parties and generally not intended as a binding agreement enforceable by the court. Other titles may be used for the document, such as Memorandum of Understanding. So what do we mean by sustainable? Next slide, please. Well, sustainable in our mind is a document that is clear and understandable. It's designed to minimize future conflicts. It provides sufficient detail for the legal professionals to be able to draft the necessary formal documents for settlement to be binding on the parties. And so this may be a formal separation agreement, or it may be minutes of settlement if the matter is in court. It clearly identifies when parties agree to terms that are different from the legal model, and more importantly, the why for the compromise. This concept is also critically important in the later drafting of the separation agreement or minutes of settlement. The reason why the why is so important is that when other professionals, such as lawyers or judges, look at the mediated resolution, they will be comparing it to the outcome from the legal model. If there are discrepancies between the mediated settlement and the legal model, it may not be clear whether the difference is as a result of the conscious, informed choice on part of the parties or some sort of mistake, unless you include the specifics of the compromise and the rationale are clearly set out. As an example, oftentimes you can put in some language that says spouse A is owed an equalization payment of X dollars, but has agreed to reduce this payment to Y dollars in consideration for spouse B's agreement to do something else, some consideration. The absence of this explanation can lead to a questioning of whether the terms reached by the parties during mediation properly reflect the parties' intentions. But if the explanation is included, those professionals will be able to satisfy themselves firstly as to whether the parties knew what they might otherwise be entitled to, and secondly, the basis for the compromise. Next slide, please. There are 4 key pieces of information that ought to be provided to the to the client and the advice lawyer, along with the mediation report. And those 4 things are as follows. The first is progress notes. And those are notes that detail the discussions between the parties at each mediation session. The second is whatever financial documentation has been produced by the parties and exchanged during the mediation. The third is whatever calculations have been prepared and relied on by the parties in reaching the terms of settlement. And fourthly, again, sufficient detail regarding any concessions. This information will make the provision of legal advice to the client more efficient and cost-effective. Providing this information to the parties and his or her lawyer saves time for the lawyer to effectively review and understand the negotiations which have taken place. Less time spent on the part of the lawyer translates into cost savings for the client. The progress notes explain the issues and the discussions which have occurred between the parties. The financial disclosure, as you've heard, is a necessary component of providing advice, and so it only makes sense to share what has already been exchanged between the parties rather than putting them to the extra work of reproducing it for another professional. Calculations allow the advice lawyer to see how they were made, what factors were considered, and satisfy themselves that no errors were committed. The explanation regarding any concessions, again, allows the lawyer to be able to zero in on these issues for discussion and advice with the client to ensure that they genuinely understand and agree with the decision to compromise. Next slide, please. What is a durable agreement? Well, this is the end product of the legal advice process. The form of that document might be a separation agreement if the matter is not in court, or minutes of settlement for court purposes. And when we talk about a document that's going to be respected by the courts, what we're referring to is that we want the judges to respect the process that has taken place. Judges want parties to resolve their own family law disputes. They recognize that they're in the best position to do so, but they also recognize that the intimate relationship between spouses creates challenges and risks due to that relationship, and they want to ensure the negotiation process has integrity. Not to be overly simplistic, there are 2 key elements that a judge is oftentimes going to want to be satisfied of before they decide to either respect and uphold the agreement in the face of a challenge or to set it aside. The first of these key elements will be, was there full financial disclosure? Because if a party has insufficient factual information to be able to make informed choices, a judge is unlikely to hold them to the bargain reached. For example, if someone accepts or agrees to an amount of child support without knowing the other party's income, a judge is unlikely to hold them to the bargain reached. Secondly, did the parties understand their options so as to make an informed choice about the bargain they negotiated? Again, as an example, if a party chooses to waive spousal support without understanding the law on spousal support entitlement or access to information regarding how amounts of support can be calculated under the spousal support advisory guidelines, a judge may very well set aside the agreement. Often a certificate of ILA is presumed to be proof that a party has received this information, but as you heard before, it's not an absolute necessity to a completed document. To the lawyers in the audience who may be drafting these agreements, don't be afraid to put in additional information or background into your settlement documents, particularly if it will provide clarity on these 2 issues for anyone reviewing the document in the future. For an example, I always attach the net family property statement that was prepared during mediation and relied on the parties in reaching the mediated agreement. So it's easy in the future for someone to see the foundation for the calculation and what assets and liabilities were included. Next slide, please. Now, convertible minutes of settlement doesn't mean that we're expecting mediators who have a different background than law to actually draft minutes of settlement. But we are instead aware that sometimes the process from getting a mediated document, particularly in a court-connected situation, through to something that judges can use can be a bottleneck. And so we want to eliminate those. We're recommending instead that mediators be aware of the court needs and expectations to try to make that process of converting the mediation report into a document suitable for court much more streamlined. Make sure that you understand that there might be regional differences in practice or judicial expectations. For example, some court-connected mediation sites have worked out a template for a tick box of common terms to be included in any minutes of settlement or consent order to avoid having to draft everything from scratch. This just makes the mediation report something that then is easily transferred into the necessary documents for filing with court. I also would like to point out that in addition to this video, we do have a written companion guide. And at the end of that written companion guide, which you will find along with this video, is a PowerPoint entitled Minutes of Settlement, 10 practice tips. And so if you review that, you'll find examples of common drafting errors and tips for better drafting. Marianne?
Nice. Thanks, Janet. It's interesting listening to your presentation and thinking about drafting for family mediators. I think we're sort of in the same, we have the same goals. And really, when you're a family mediator and you're also not a lawyer, we have to think about the 4 key components that Janet spoke of. And in addition, a few other bits and pieces I just wanted to highlight. And so when we're drafting, we want to make sure that the mediation report or memorandum of understanding or whatever title you're giving this report is clear and appropriate for the needs of the family. So we really want to keep that family focus and really not take a cookie cutter agreement and apply it to a family, but take the family and draft the agreement so that it really is representative of what they have agreed to, and also why they've agreed to it. And I think when we're drafting mediation reports, you know, the independent legal advice lawyers are not right there in their room with us the whole time in some cases during mediation. And so really to add a why, like for example, the parents agreed not to separate their RESP accounts, and you know, the parents will do X, Y, and Z with it instead. We are going to include why potentially into that scenario, or anywhere that there's just the reader may have a question. We really need to give that additional information, whether that's in sharing progress notes or drafted right into the mediation report. The lawyers have the opportunity to have that knowledge, and then they can edit out pieces that are not pertinent to leave in the final separation agreement, at least though that it's there so the lawyers can see and understand. And then, as Janet said, looking at the legal model, what the legal model might look like, and the settlement model that they've agreed to, and sort of if they've agreed to leave out the value of a car, for example, on both sides, or you know, even a bigger item like one parent is keeping the matrimonial home, and the reasons really need to be clear in the mediation report. You know, for example, you know, one recent client had 2 children with extreme special needs, an excellent school, a good IEP was worked out. Dad was receiving a home from his parents in the next couple of months. And so the, you know, that reason was set out so that the lawyer could understand and not get a reactive opinion when reading the document. So if I had not included the reasons, the lawyer could have very you know, understandably said, what on earth is this? And so as mediators, we want to stop, what on earth is this? We want to go back to the beginning of this presentation and think about communication. We have to think about our relationships with each other in order to make sure that we understand the needs of you as lawyers who are providing independent legal advice. We need to share as much information as we can. We need to call each other and say, hey, I'm working with your client. what would you like the mediation report to look like? What would you like, a fulsome report? Would you like, key components of understanding? What can I do to help you, to help your client, to give them good independent legal advice? And then also there's the idea of making sure you've got good data exchange. So you're wanting to share the calculations, the valuations, the tax returns. How are you going to securely exchange that information? And back to you, Janet.
So if issues arise during the advice stage after the mediation is completed, what do you do? Next slide, please. I always tell my mediation clients that if the lawyer providing them with advice has any questions, to have that lawyer call me to discuss. And so I would suggest that to everyone else. If there are questions, pick up the phone. Don't jump to conclusions. I had that situation happen once where I had completed a mediation with a couple. They both went off to lawyers, and the wife's lawyer didn't really understand what was happening with the spousal support and the review provisions. But instead of calling and asking, jumped to the conclusion that it was a terrible result, it was a terrible term, and that inferentially I was a terrible mediator. The good news is that we were able to get all of those relationships back on track. We set up a time where both parties and both lawyers met with me for a brief 2-hour session to go through everything. And once the lawyer understood what the goals were and what was happening, all of a sudden they went, oh, okay, yeah, that actually makes a lot of sense. And so we could have saved everyone a lot of grief if she would have just picked up the phone and talked to me. But remember, when you're calling the mediator, remember that that person is the neutral. They don't act for anyone. And I certainly have had some situations where lawyers have made other assumptions that somehow, because I'm trained as a lawyer, but I'm acting in the capacity of the mediator, that somehow they just need to tell me what the problems are, and then I can go ahead and renegotiate everything with the parties, and that doesn't happen. But if there is an issue, have the parties potentially think about, coming back to mediation either on their own. So if an advice lawyer has said, hang on, what about this? Maybe perhaps it wasn't considered during the mediation session. Maybe the parties hadn't raised it as an issue. Perhaps, the mediator hadn't thought about it. We all try hard, but that doesn't mean that we're perfect. They can come back for a brief session to try and work that out. Or as I gave in the other example, maybe you convene a short mediation that includes the lawyers to work through any of those kinds of problems. Again, remember that we can all be more effective if we just work together as a team for the benefit of the separating parties. That's the end of our formal presentation, but I just need to thank a few people before we finish. In addition to the support received from the OAFM and LawPro, I need to thank a few other people. Firstly, Nigel McLeod, a lawyer and accredited family mediator who provided much valuable insight during the earlier stages of this project. He has now gone off to enjoy a well-deserved retirement. From the Winkler Institute at York University, I want to thank Professors Shelley Kirsten and Trevor Farrell for their constructive feedback and support throughout the work of this project. I also need to thank Mathura Sinadurai and Benjamin van der Wint, law students from Osgoode Hall Law School, who assisted us with the compilation of the companion guide, which includes the points from this presentation in writing, together with a best practices guide. Please note that the material and all of the written material in this video will be available on the OAFM website and the Family Law Limited Scope Services Project website. Thank you again for your time.